We've got a bit more practical scenarios that I just wanted to run through with you and get your opinion on how it could happen and sort of, I guess, some of the situations that might come up in sort of daily work environments. So the first one is an employee's household member has a violent partner who does not live in the same house as the employee.
Yep.
So is my employee then entitled to leave and to provide support to their household member?
Yeah. So again, we're looking at this two-pronged attack or a test. The first has to be that it's got to be violent, threatened, or abusive behaviour by a close relative of the employee. So a partner does meet the definition of a close member of the employee's household, or a former or intimate partner. And then the second part is that they seek to coerce or control the employee and cause them harm, to be fearful. So in regards to this scenario, it would be that you would be obligated to consider this leave, and you should consider this leave. However, if it isn't that definition of close relative or a member of their household, then it wouldn't be. So in this scenario, it really would depend about the violent partner isn't in the household, but are they still considered a close member or close? So if they satisfy one of those, they'd be sufficient to be considered domestic or family or domestic violence leave.
Yeah. So the next one, an employee's partner has been accused of family and domestic violence from an ex-partner, which I guess is causing stress on the employee and obviously the partner that's been accused. Does this situation fall under family and domestic violence, even like in the circumstance that it's the partner being accused of it with no evidence or nothing that the employee is immediately experiencing?
Yeah, so then that comes back to, as I said, that part of the test that I think is open to maybe not understanding. It's got to be against or towards either an employee or a member of their household or otherwise. So given that the partner is alleged to be the perpetrator, it isn't towards him, and therefore your employee wouldn't be allowed leave because she's supporting someone who's being accused of it, as opposed to who has suffered it or is alleged to have suffered it. So in those circumstances, no. But again, I implore employers to maybe put a light over it, that, each individual circumstance would be unique to that. So, there may be circumstances where you'd want to go above and beyond, but in terms of the definition, it will not meet that definition.
So if an employee has used all of their family and domestic violence leave in sort of that 1 10-day block, but then comes to work advising that the partner has been violent in some way, can they access family and domestic violence leave in advance for their next 12 months? Or if not, what type of leave would they be on?
Yeah. So this is a good one, because I think it will be a scenario that will come up. Someone may need to be off work for 2-3 weeks in a block. So technically they're entitled to their 10 days paid. Then they could, in terms of minimum entitlement, then go on to unpaid leave, or they could take it as carers or personal leave if it satisfies that, or they could do it as a flexible working arrangement, which is what I talked about before, that maybe they work from home for that period, or they work 4 days and have 1 day. So they can mirror it in with other awards, but they're not entitled to take it in advance. But the employer can give more than that entitlement as well. And I think the only bit of caution will be, if you think you can give it in advance, if you do that, I think there still will be issues about compliance with the legislation. So, it'll be similar to, people who cash out annual leave when you can't. You can, if you do it, you can't do it. So they still have that right to annual leave at the end of their employment. It'll be similar to that if you give it in advance, months, I don't think you'll be able to say, well, they've used it up, so they can't get it in the second 12 months, because that's not what it says. It says it rebounds at the 12 months. So I certainly wouldn't be considering giving it in advance. I'd be considering paying it as more leave, unpaying it, giving them personal leave, letting them take annual leave, letting them do a family work arrangement. And again, individual circumstance and assessment for that. So I think what it's important for an employer to understand is to be fair, they don't have to implement the same measures for everyone. You know, there may be different measures depending on the longevity of the employee's been with you, the type of what the employees disclose to you and what they're suffering, what the employee needs and what their needs are, what the business needs in those circumstances. So it's really important to agree to assess this on an individual basis. And as long as you're meeting the minimum entitlement for everyone, you can give beyond that.
Yeah, that's great advice. So another scenario is that the employee is confided they are the perpetrator, and I guess as a business owner might be concerned for other employees' safety and not necessarily sure they want to continue to employ this person, given that they now know this information.
Yeah.
What should businesses do?
Yeah, it's a difficult one. Again, the employee should know about it in the first instance, but all the employer can control is obviously the disclosure of information from the employer. If the employee is going around to everyone saying this is what's happened, well, they're all going to know about that. Or the ex-employee, you know, you often find them contacting the perpetrator's friends or work colleagues and telling them. So when it's out there, what you as an employer have an obligation to do and ensure is everyone's health and safety. So the same exists like at present for, say, if someone had been convicted of a sexual offence and then people in work know about that, we often find employers coming to us and saying, well, you know, no one wants to work with this person because they've been convicted of it. You as the employer only have the right to enforce it to the extent of health and safety. So if this domestic violence event and this perpetrator was specific to the employee, to his partner or wife who doesn't work for you, and there's been no, you know, evidence of it occurring at work or likelihood or reasonableness that it could occur at work or towards anyone else, you wouldn't have the right to say, well, I'm standing you down or you can't come to work or otherwise. You know, you don't have the ability as an employer to dictate that. You only have the ability to ensure health and safety. So if this person had a violent episode at home against his wife and then he came and had the same at work or continued that, then 100% you'd be sending that person home. They wouldn't be going on domestic violence leave. You would be standing them down pending an investigation into what they're doing. And if they're not fit to be at work, then they're on personal leave, paid or unpaid, until they are fit to come to work. So yes, you make it your business if it's a risk to your employees' health and safety, which includes the perpetrator. So say, for example, the perpetrator is alleged to have happened, but then he spirals or she spirals into, you know, mental health issues and depression, then that would bring it in the workplace. That employee would have to go out and be assessed, but that would be personal leave, not domestic or violence leave. But again, case by case, again, you know, you need to contain it. But as I said, the area that I see could be an issue that arises is the same as you do with if employees say, I don't want to work with this person because he's engaged in domestic violence against his partner. Unfortunately, that's not necessarily enough for them to say that, and you've got to find a way to satisfy your employees that you're looking after their health and safety, but not breaching anyone's right, which is, you know, innocent until proven guilty, and that there are matters outside of work in most circumstances. So it will be a difficult balance. And all the while keeping confidential as well. So if an employee came to the employer and says, I know that, you know, he bashed his wife last night or physically assaulted his wife, you as the employer aren't allowed to disclose what you know because the employee's taken the leave. So I'd be trying to, again, if that's where you've got defined officers who deal with this, defined people, you need to shut that down as quickly as possible and make sure that there aren't any inadvertent disclosures of what you, the employer, know.
Yeah, absolutely. So another scenario might be an employee's partner is particularly violent, has come to work while the employee is on that family and domestic violence leave, and they're demanding to see the employee. I guess from a business perspective, how do I protect my other employees without breaching the confidentiality of the employee affected by their partner, and also protecting the employee's privacy?
Yeah.
And not necessarily, like we sort of touched on before, disclosing, yes, they're on leave, family and domestic violence leave, not disclosing that specific.
Yeah. And that, so I think there's two things then. It's one, the health and safety of your employee whose partner has come on. So your partner doesn't work for you, but they've come on. It's how do we ensure their health and safety? And that would involve obviously health and safety obligations, but also this family and domestic violence leave. It might be, okay, you can't be at work because he's going to keep turning up to work. You want to go into, you know, hiding or something, then you could work from home for that period, or it could be express instructions to front office to say, if anyone comes looking for this person, you're to put it through to me and say they're not available, or so you'd have to take measures to stop it. But it would then bring it into being a work matter, because if he turned up to work and displayed violence, then your other employees are at risk of health and safety. You know, their health and safety is at risk. So you've got to approach it then from a domestic and violence leave perspective and requirement to keep confidential, but also a workplace incident that has occurred and that you have to have measures to put in place to make sure people's health and safety. So it will be difficult to balance it in those circumstances. My suggestion is you separate the two. As I said, okay, Tom is looking after your leave and what that entails and what evidence you have. We're investigating this workplace investigation over here, and measures will be taken about that. And it'll be limited to what he did, what the partner did when he came to work. So, yeah, it'll be learning as we go and making sure wherever possible there's no disclosure, but areas like this will morph over, and there will be circumstances where, you know, you're going to have to think outside the square a little bit.
Yeah, absolutely. And I guess as you touched on before, case law is going to come into this more as sort of the more businesses, and certainly when small businesses come on board from 1st of August, that will, I guess, iron out some of these specifics and work on some of the particular scenarios as well that are sort of unknown at this stage.
Yeah, very much so. And you know, it's important for an employer to also understand those ongoing changes, because it will, I think, hopefully we might even get some guidance in terms of a guide from the Fair Work Ombudsman or otherwise. They do have one on the website at present, but it's really covering what we're covering today. But there is talk that there'll be a more in-depth, you know, policies and procedures around it. And certainly after this, your members can get access to a checklist, which will be really good for them to come back to basics and be able to say, this is what I need to make sure is happening at a minimum.